Ex-Cowboy Josh Brent's blood alcohol level was more than twice the legal limit, .18, the night he crashed his car and teammate Jerry Brown died. Well, now, Brown's attorney wants the blood test thrown out. He says the way police got his blood was illegal, and he says a recent Supreme Court case backs him up. Fox 4's Sean Rabb has the story.
The blood draw taken from Josh Brent the night of the accident that killed his best friend, roommate, and teammate Jerry Brown, taken without consent and without a warrant.
Given the situation as it existed during this investigation, they should have obtained a warrant.
Milner points to an April 2013 Supreme Court ruling that says an officer cannot legally obtain a blood specimen from a defendant without that person's consent or a search warrant. In its opinion, the court writes, even though alcohol dissipates as time goes by, that fact alone does not constitute exigent circumstances under the Fourth Amendment. Exigent circumstances is a circumstance that requires an immediate response and allows law enforcement to act without a search warrant.
Would he have to be tending to wounded people at an accident or assisting with the accident scene, things that would take an inordinate amount of time that would take him away from being able to do a DWI investigation? Well, that wasn't the case.
Attorney Toby Shook not involved in this case.
I think this is a very relevant motion. This covers the facts of this particular situation.
The state's response argues Josh Brent could not adequately perform parts of Phil's sobriety test, refused consent to blood draw, and when his blood was extracted, offered physical resistance, and that Texas law gives implied consent. The state continues, having chosen to operate a motor vehicle in a public place, the driver has no legal right to interfere with the taking of a blood sample. His blood is automatically subjected to a potential search based on his decision to drive while intoxicated. Toby Shook says Milner's argument is sound, but doubts the judge would grant his motion to throw out the blood evidence against Josh Brent.
There's pressure, obviously, because there's tremendous scrutiny, and judges, if it's a gray area, are hesitant sometimes to grant motions like this.
Now, the hearing on the motion to throw out the blood work of Josh Brent is set for August 30th. If it's not thrown out and if they lose in court, Steve, well, then that sets up an appellate point for George Milner and Josh Brent going forward.
All right, let's talk about this. We're in Studio B now. Sean, it sounds like from the statements you've gotten that the DA thinks that state law supersedes whatever the Supreme Court, right? I mean, it's talking about if you're driving on Texas roads, we can take your blood.
Yeah, there's a part of the transportation code in Texas that says if you're driving on Texas roads and if you have an accident and there's serious bodily harm or death, then your blood is subject to search. But today, the Dallas Police Department sent out an email to its officers saying, right now, don't use that part of the transportation code. Make sure you get consent or make sure you get a warrant to take someone's blood.
Do you read that as somebody in the DA's office or somebody in the police department isn't so sure about in the future? Well, the Texas statute does supersede.
I think it's somebody in the DA's office because the email reads kind of in following the recommendation of the district attorney.
Yeah, all right, Sean Rabb, we'll see. Quickly, is this case going to get tossed on this?
Well, it's a high-profile case,
yeah.
And now, the judge probably is going to let it play out.
There's some pressure, right?
A lot of pressure.
All right, Sean Rabb, thanks.